Mark, I'd like to get your thoughts on this, that this was Ethan's best friend who actually made the discovery of the bodies. It wasn't first responders who discovered the bodies. Up until now, we'd always assumed that perhaps they were behind locked doors, and that's why the roommates had called, "We can't wake our friends up." But it was Ethan's best friend. Not only that, took the pulse, called out to call 911, and ended up talking to 911 on Dylan Mortenson's cell phone. Does that matter? There's so many details that are being held close to the vest, Mark. And I just want to, from you, find out if it really matters to the investigation. Does it matter to the rights of the defendant in this case, these kinds of details that are all being gagged?
You know, I've always had, Ashleigh, and you and I have been around together doing various cases for many years, ones that I've tried and ones that you've covered. And one of my frustrations in defending these cases is when you clamp down on the coverage, and you do it by way of a gag order. And you'll remember many years ago that started during Michael Jackson and Scott Peterson and then Kobe Bryant and it was basically the same gag order that was kind of circulated, even though it was in different jurisdictions. And the frustration is that gag orders were originally, when F. Lee Bailey did his case many, many years ago, that put him on the map, and it was to protect the defense. Now what it does, I think, in my humble opinion, is that it works to the detriment of the defense. And what ends up happening is you might be able to gag the lawyers, they're under a duty, but law enforcement leaks. Other people leak that are connected, that may have documents. I mean, the DeLorean case, I remember the paralegal leaked for the defense. And so what ends up happening is you get all of these kinds of urban legends that kind of flow to the case and to the populace. And there's no way to disabuse people of that. Even when you do jury selection, they just don't, they think they understand things, and it's very hard for people to disabuse themselves or set it aside. I always think in these kinds of cases, more information is better than less.
You know, and I just want to touch on that because there is a healthy debate among people who are looking at this case. The First Amendment versus the Sixth Amendment, the right to a speedy trial and a fair trial, an impartial jury. But we also have a transparent system of jurisprudence in America, and that is very important. You know, that's something that not a lot of people talk about as well. And I wonder, from your perspective, because you've covered these famous, infamous, I should say, defendants, if you can get a jury for OJ, if you can get a jury for Casey, if you can get a jury for John Wayne Gacy, even, I'm going back a bit here, but do you know what I'm saying? If you can get a jury for those people, is there a danger of protecting a jury pool too much to the detriment of our system in America, where we just don't put people in black hoods and throw them in a gulag?
So I've had this argument for decades, and part of what the argument that I've made in response is we have reached a point where we have supersized cases. Idaho is a supersized case. So if you're going to import kind of a tabloid model, and I don't say that in a pejorative sense, I say it what originally kind of developed in England, then why don't we have what's called the Contempt of Court Act, which they have in England, which is as soon as this trial starts, they clamp down. Now, you say, well, that's not part of the American way. Well, then there is another alternative. The other alternative is, well, once you start the trial, sequester the jury. And why I say that is, if you believe the jurors when they tell you they're going to set aside everything they've heard, which is great. I want jurors who have a presumption of guilt many times because they're being honest with me and they'll set it aside. But if they're going to do that, then I want to be able, and I want to be free outside the presence of the jury to argue that evidence should not come in. You take a look at the Murdaugh case. There was so much testimony for the motions in limine outside the presence that seeps into the ether. Jurors are going home each night. I've never got a high degree of confidence that they don't hear what was presumably excluded. So if they're sequestered, I think that's the magic silver bullet.
Okay. Well, Mark Geragos, I'm always fascinated in what you have to say because, like I said, you've been there. You've been in the courtroom with very famous people as defendants beside you, and so you know from the other side what it's like. Thank you for this tonight. Look forward to our next time.
Thank you, Ashleigh.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.